Nisqually, your name, please.
I am not. Forgive me. One moment. My name is what you asked
Yes.
for?
I did.
No, I am not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports. He was
Who is him?
Don't interrupt. I'm letting
I read him.
Langley go. You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
Wow, right out of the gate, you can see this is going to be a difficult hearing. Instead of simply saying his name, Milton launches into this sovereign citizen style explanation, insisting he's just an agent for himself. Judges have seen this tactic before, and you can tell the judge here is already trying to ground the conversation in reality. It's awkward, but also a little sad, because this confusion will only hurt his case.
Swear the testimony probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She writes that on March 31st this year at approximately 13:53 hours, she responded to an unwanted person complaint at a 7-Eleven store located at 2425 Marvin Road Northeast in Lacey. Dispatch advised a male was refusing to leave the store and was being disorderly, yelling at staff. Upon arriving, Officer Evers contacted staff, who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. They advised that at one point the male stated he would be waiting outside when they got off work. The staff advised that they asked the male to leave multiple times and he refused. They also advised that once they called the police, the male returned to his Toyota 4Runner, and the license plate is provided here, and then that it was parked outside the gas station. Staff provided a prepaid phone and a charger that the male had left on the floor inside. Staff stated that they didn't feel safe, wanted the male trespassed. Officer identified him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable. Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property, since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. Then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. So then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Peyton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail.
This police report is pretty straightforward. Intoxicated, threatening staff, refusing to leave. What really stands out is Milton's repeated line, "Too drunk to be held accountable." That's not a legal defense. In fact, it just shows the risk he posed to others. The staff felt unsafe, and that's why they wanted him banned. This isn't a minor misunderstanding. It's a pattern of escalation fueled by alcohol.
And Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot, in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment. So it is never a smart thing to represent yourself, and frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel, and if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay.
The judge actually takes time here to protect Milton. Most judges would rush, but this one goes line by line explaining why representing yourself is a terrible idea. It's almost fatherly advice. Yet Milton insists on pro se. It's a tragic example of pride, paranoia, or both leading someone to sabotage their own defense.
Not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
Like I said, I can't represent you. You're going to have to figure all that out yourself. For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
Okay, I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me. Have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay.
This part almost veers into comedy if it weren't so tragic. Milton demands 4 to 6 hours of unhindered internet access so he can research his case, like jail is a public library. He even claims he can't legally be charged because there's no victim. These are classic pseudo-legal arguments, and they collapse instantly under scrutiny. But he clings to them like lifelines.
Or not?
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key. Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Which is one of the reasons. Don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
The Miranda confusion is telling. He thinks not being read his rights makes the entire charge disappear. The judge patiently explains. That's not how it works. At most, it limits how statements can be used. Again, Milton shows he has just enough legal vocabulary to sound confident, but not enough to understand the law.
Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you.
Cool. Well, I have $100.
Okay. All right. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case, just so you know you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made.
Here's the crushing reality. Bail. The judge sets it at $1,000. Not huge, but for someone living out of their car, it's insurmountable. Milton admits it's closer to impossible. And this is where mental illness, poverty, and addiction collide with the justice system. He's trapped.
I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal, and I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour.
Okay.
So,
all right, we got that.
Yep.
Milton accuses the jail of torture during intake and references anti-kidnapping training. Whether that's delusion, exaggeration, or truth, it's another sign of how fractured his thinking is. The judge politely acknowledges but doesn't dwell.
Evidence after I signed this, and I was never taken a statement from.
Okay, so what this is on for, and Mr. DePister, are you still there? Did we lose Mr. DePister?
Ms. Langley's case, Your Honor.
Ms. Langley, can you come on the Zoom call there, please?
No objection if, the defense needs a breakout room to talk about it.
Give me just a minute there, Mr. Sharp. So, Mr. Milton, you're here on a simple assault charge.
Right.
And it's scheduled for a plea of guilty. So when anybody ever gets charged with a crime, they have kind of 1 of 2 routes to take. They can either take it to trial or plead guilty, or the state can, or the prosecuting authority can dismiss. So I was told you want to plead guilty here today, and once you plead guilty, it's true. All the rights contained in paragraph 5 of that plea form go away.
I don't know.
Hang on, let me finish, please.
Yeah, sure.
If
Yes,
you
Your
don't want
Honor.
to do that, then you don't have to, and then we'll just set this for trial, and this case will resume. So that's where we're at here. And if you want to go into a breakout room with Ms. Langley to discuss this further, you can do that if you wish.
Yeah, I just want to clarify, this would be an SOC, not a plea of guilty.
Okay. Well, that's true that if the thank you, Ms. Langley, if the stipulation in order of continuance is revoked, if there's any problems, then yeah, that's true. The guilt or innocence will be determined by a reading of the police report. So what's happening there is you're giving up your right to a trial, the right to present evidence, but what you're getting is the opportunity to have this thing completely dismissed. And so if you don't want, again, you don't have to do that either if you don't want to, but that's what's happening here today.
Well, Your Honor, what I'd really like is for, first off, my statement to be taken. Second off, for details that are imperative to my defense to be taken. And finally, I mean, realistically, I'd hate to be incarcerated for a crime that I didn't commit against an assailant who's known to assault people who are...
By the end, Milton doesn't even understand the plea deal. He wants his story told, insists on innocence, and feels railroaded. Whether he's guilty or not, the bigger issue is clear. He's lost in a system he doesn't understand, and by refusing help, he guarantees a harsher outcome.